Hello, everyone. Welcome to Antonette's podcast. This is the third podcast in a series of podcasts on the books that I have published and written. The book I am discussing at this point in the podcast is Law, Race, and the Constitution in the Obama Context. Now, in the last two podcasts, I looked at the introduction to the role of the African American attorney in the 21st century. And then I talked a little bit about the role of not just the African American attorney, but also the African American professional, generally being the center of the family unit, and also being specifically the African American attorney being a mediator between the larger social environment and the larger context and the kind of micro context, meaning the family unit, the individual unit, one looking to enhance one's own economic viability, and also mediating the context of the greater environment, politics and education, and the general considerations of law and social change. And so I looked at Frantz Fanon, who wrote The Wretched of the Earth and was a philosopher and an activist and he an academic and scholar and just a person who was concerned with cultural education and cultural information and sharing the information with the masses for the benefit of society. And so I looked at Frantz Fanon, The Wretched of the Earth, and quoted him. And in that quote, I basically talked about the notion of compromise is very important in the case of decolonization. So I mapped the colonial context into the United States context, looking at, sometimes there have been movements in the United States, but there have also been movements in the colonial context, and there are certain similarities between the professional in the colonial context and the professional in the United States under the slavery regime and then coming out of the slavery regime in the U.S. And so I looked at Frantz Fanon and his theory. I looked at mapping the colonial context. I looked at the role of the African American attorney and the role of the black professional in society. And I essentially gave a background and investigation of the role of the attorney being one who has such responsibilities to handle in terms of working with family and working with friends and helping individuals to have knowledge and information and education and also providing financial assistance to family members and others if necessary. And just being kind of the rock of the family, and different individuals play that role. The African American attorney has a special role because they have specialized knowledge, not just the knowledge of being, or not just the strength of being an individual in the family, but also the specialized knowledge of the law, which is very necessary in this context. So now I'm looking at Charles Hamilton Houston and the birth of the idea of the social engineer, and discussing a little bit about the social engineer. So I'll begin here. Undoubtedly, one must first acknowledge the contribution of Charles Hamilton Houston to the legal context in developing the idea of social engineering and the liberation struggle of people of African descent in the 20th century. Collins, an author I'm quoting, suggests that Houston's contribution to the social fabric of American society and his unflagging dedication to the work of social engineering impressed upon lawyers the need to challenge oppressive systems and to display intellect and courage when faced with difficult situations. Furthermore, because of Houston's contribution, the legal context has changed dramatically, including groundbreaking changes in labor law, environmental law, civil rights law, and criminal law. His work has implications for the American context in light of the ironic radicalism of his gradualist approach during a highly charged historic period. The role of Houston's idea of social engineering, though evolving, has had and continues to have far-reaching impacts in terms of mainstream law. It is no doubt that the challenges Houston faced in the early part of the 20th century reflected a landscape of discrimination and oppression. These early years of the 20th century were plagued with wars, economic depressions, and interracial strife and conflict. World War I and World War II, the Great Depression, and legalized segregation ensured that the American landscape remained politically, socially, and economically charged. This energized society, however, was conducive to change as aspects of American life seemed to be in flux. In hindsight, while the risks of civil rights and racial justice advocacy were high and prevalent, it also can be said that America's constant state and rate of change ushered in a time amenable to legal conversations of equity and justice. Nonetheless, historical barriers of enfranchisement, education, housing, and employment created an untenable situation for African Americans in the United States. Thus, while experiencing change, the courts seem to be maintaining status quo precedent with regards to matters of race, making it a particularly difficult feat for Houston to advocate for African American rights and liberties. Houston's work preceded the civil rights movement, but affected change seen in the movement. The de jure and de facto segregation and racism rampant during Houston's time made his accomplishments during the early 20th century and those of the civil rights movement all the more gargantuan. Houston's approach of chipping away at segregation through the judicial system is comparable to and the forerunner to the politics of opposition of civil rights leaders and black radical organizations. Black radical organizations such as the Congress of Racial Equality, the Student Nonviolent Coordinating Committee, and the later Black Panther Party worked in cahoots with more moderate civil rights organizations in a bad cop, good cop relationship. And so what we see here in this good cop, bad cop relationship was to force the establishment to amend legislation, enforce equitable laws, and enact policy that reflected the inalienable rights denied African Americans. This strategy is undoubtedly in part attributable to Charles Hamilton Houston's approach of challenging the judicial system to legislate from the bench based on oppositional positions within the legal framework and practice. And yet, Houstonian logic was only as instrumental in change to the extent that Houston operated in the confines of the legal system of the U.S. Similar to Houston, African American attorneys today are forced to assimilate into bourgeois society in order to survive. Just as Houston worked to change the face of the law, African American attorneys must first prove themselves competent before being allowed to be spokespersons on behalf of the race. The African American attorney must demonstrate mastery of the law and culture of the legal profession. He must be an example of logic, rationality, and resolve. And yet, his ability to be persuasive comes from a place of ethos, rhetoric, and morality. Thus, the African American attorney must be nuanced and versed in the status quo before attempting to create change, regardless of the details of the frontier in which they find themselves practicing, the 20th century or the 21st century. And now looking at, so this we see with the Houstonian becoming of the social engineer, that there have been certain hurdles, but we see that it occurred in a context that was in the face of the civil rights movement, and on the heels of the World War I and World War II, and it looked at the changes in law in the legal system and adapted and also changed and re-envisioned the law in face of these changes. Now, moving forward to the Houstonian approach and the goals of social engineering. The goals and meaning of social engineering have evolved over time. In the practice of social engineering, Houston's approach to legal precedent was described as legal realism, sociological jurisprudence, gradualism. Christopher Bracey, of George Washington University Law School, attended Harvard University for law school, argues that he was former dean, uh, uh, former acting dean at George Washington University Law School, and a professor at George Washington University Law School, and a dean in other capacities. Bracey argues that Houston's mastery of legal realism was central to the success of his legal practice. Hogan and Smith further point to a well-documented history of the Houstonian approach, which involved urging the courts to face the reality that social and economic burdens were attendant to the constitutional policy of separate but equal. They then go on to say that the Houstonian approach was based on national social and economic policy, end quote, taking note of sociological evidence. Fairfax challenges the idea that the whole of the Houstonian social engineering approach was the legal realism that responded to judicial restraint, which had struck down progressive measures. Rather, he states that Houston was influenced by sociological jurisprudence, but recognized the inability of legal realism to effectively respond to racism because of his deference to the legislature. Fairfax argues that Houston's reliance on judicial activism signaled the beginning of the end of the liberal consensus on the principle of judicial restraint. However, Bracey contends that judicial activism is in fact legislation from the bench, and as such, there has been deference to the legislative process, whether congressional legislation or judicial legislation. Thus, Houston's use is not distinguished from legal realism based on deference to legislation. Moving beyond the nuances of the debate of Houston's approach, although such a debate considers significant implications regarding legal jurisprudence, Houstonian social engineering undisputably challenged judicial restraint in favor of judicial advocacy. In the courtroom, the Houstonian social engineering approach of using sociological jurisprudence was targeted, while the courts historically used a strategy of judicial restraint when deciding matters of race. The Houstonian approach introduced social science and supported judicial activism. The Houstonian approach assumed that changes in legislation needed to be aided by judicial advocacy and newly set precedents in cases of discrimination and racism. This approach was successful in not only litigation of several cases, but also in creating precedent for future attorneys who would go on to call themselves to be trained as social engineers. So I'll stop here with this particular recitation of my book, Law, Race, and the Constitution in the Obama Context, where we've looked at how Houston's approach is having an impact on the legal system, looking at judicial activism, looking at legal realism, looking at judicial advocacy, and the limits of the perceived limits of the Houstonian approach because of legislation and the legislature, but also the great opportunities for the Houstonian approach and Charles Hamilton's Houston's advocacy through legal activism and sociological jurisprudence, essentially using sociology and certain other statistics and certain other means of arguing the law. And so, furthermore, looking at scholars and their discussion, including Bracey and Fairfax and so on and so forth, and their discussion of what were the hegemony or hegemony, however you want to pronounce it, the hegemony of legal scholarship, and what the foregoing and existing research said, and what the overall perceptions and opinions of Houstonian logic and Houstonian approach, what the Houstonian approach was during the time of Charles Hamilton Houston, and also as we moved into the 21st century. So this concludes my podcast, and again, this is Antonette Jefferson. I am the author of 10 titles, and I possess several degrees, for 6 degrees from 6 universities. And I look forward to our next podcast and for you joining me on the next podcast as we continue to investigate, evaluate, looking to research and understand and delve into the Charles Hamilton Houston and the Houstonian approach in social engineering and the role of the African American attorney and professional in the 21st century and beyond the 21st century, and even in centuries prior to the 21st century, 20th century, and prior. So thank you, and enjoy your evening.